unajua vile wao waliwasaidia ile wakati. Ndio maana wanalipa. Tuongee.
If you look at the charge sheet before you honor, with the greatest respect, it's a simile or metaphor, it's not an offense, it's someone's opinion. So if the totality of the charge sheet, and I don't have to read these long-winded words, literally discloses no offense, and we are urging the court to dismiss this charge under section 89.5. Even on the charge sheet itself, it does not tell you who is the possible complainant. It should be even a member of the public who got irritated, or a person who thinks that these works could have been, who identifies themselves as the one whose behavior is likened to a dog. I want to leave it there, but my colleagues, we will not, two or three colleagues will add on to that.
Thank you, Anna. Indicate to your honor that this is the freedom of expression and freedom of speech that is on trial. To act in a manner that may amount in limiting these rights, if the same is not justified in a democratic and just society, as captioned and or provided for under Article 24, the charge sheet itself does not disclose any offense whatsoever that may necessitate the court to admit it. The Criminal Procedure Code, Your Honor, unique power, discretionary power to admit or not to admit a charge sheet. Additionally, Your Honor, our Constitution has legislated on the same under the common law doctrine of Nurem Crimen Sine Lege, that you shall not be charged or prosecuted of an offense if that offense was not known in law at that particular time of the alleged commission or commission. This is such a situation, Your Honor. The charge sheet, Your Honor, has a paragraph which does not disclose the charges that our client is about to face. It does not disclose the particulars themselves, are opaque, to make an offense out of a mere opinion. Finally, Your Honor, the statements captioned by the so-called particulars do not square out with the offense as prescribed in law. All and sundry that this is a court of law. It's not a court that is meant to square out political scores. It's only through that pen of yours, Your Honor, as you write.
Sorry, so before that happens, the court remains to settle political scores. I think you need to watch your words.
Your Honor, I rephrase.
Because you know both sides respect each
Yes,
other.
Your Honor, I rephrase
Yes,
with apologies.
yes.
That this court is a court of law, and any person wishing to settle scores should do out there and not before this court. Most importantly, as I pen off, Your Honor, is freedom that is at trial, And they say, Your Honor, deny a man anything, but guarantee him of his freedom. The freedom of expression and the freedom of speech. We still take the same route, Your Honor, that there is nothing to plead to, there is nothing to respond to, and out of nothing comes nothing. That the suspect who is before Your Honor be released on his own personal bond or reasonable bond terms. If the court will not be of the opinion of discharging him effectively, I oblige.
I was trained that seniors speak fast.
Till the time,
Okay,
they have used of the time.
okay.
Yes, I always says in settling scores, both political or social. And what we're witnessing today, Your Honor, is an incident of clear misuse of power to limit fundamental freedoms of expression. If such charges was to be brought entertained in this court of law, it clearly means that none of us is safe out there when we give our opinion or statements that do not please those who are in authority. And since we...
Your Honor, I beg to object to that kind of line of submission by my colleague. I wasn't hoping to object. I think from what I got from my senior colleagues, senior counsels, they were objecting to the charge sheet. It's not about the processes, it's not about the personalities, whatever, but let's stick to the law. As officers of the court, let's not just draw conclusion without statements, without facts, unless he wants to take to the witness block. He gives us that narrative.
I humbly respect my colleague, but I wish to statement clearly that this court, Your Honor, should not be misused by the state to limit fundamental right of expression, and the charge sheet before you is totally defective. It's our submission that our client be discharged.
Particulars of the offense. I look at section 94(1) of the Penal Code. Gives the offense for which the accused person is facing. It gives the elements of that particular offense. The purpose of mentioning these particular elements, it's in relation to the particulars. That's the quotation that my colleagues, my senior colleagues have pointed out. This section brings out certain keywords, like for example, a public place, public gathering, threatening or insulting words or behavior. And the section goes on and on. Your Honor, the question as to whether that quotation meets the provisions of section 94.1 are evidential questions. Your Honor, I refer this Honorable Court to 3 authorities when it comes to such an offense. That is Jacob Mthigangari versus Republic, Criminal Appeal number 48 of 2014.
You have a copy of the authority?
I'll provide a copy. I didn't expect my colleague to raise. Jacob Mthigangari versus the Republic, Criminal Appeal number 48 of 2014 by Honorable Lady Justice Nshemi, who looked at the ingredients and the elements of this particular offense. We run also the case of Mule versus Republic, Criminal Appeal number...
Sorry.
Mule versus Republic, High Court Criminal Appeal number 873 of 1982. And further, the last authority that I will refer court to.
Sorry, Mule versus Republic is on creating disturbance or offensive conduct?
Offensive, creating disturbance, it's which are similar, the elements are there similar.
Okay.
And another is Rehab Wairimu Thuo versus Republic, 2006, EKLR, by Honorable Lady Justice Lesitas, she then was. Your Honor, these particular authorities go to the elements of the offense and what it contains. And this Honorable Court cannot go to the quotation that has been provided in the particulars, but the nature of the offense has been brought out in sufficient details to enable the applicant, to enable the accused person response to the accusation before him. Your Honor, the other issues raised by my colleagues.
Just a moment.
The other issues raised by my colleagues, I wouldn't want to go into them on the issue of whether this was an opinion given by the accused person, because these are evidential questions. As much as we are all entitled to our opinion, but our opinion should not affect the rights of others. We therefore pray that this Honorable Court finds the charge sheet properly drawn, as drafted, and the complainant is listed therein. We so pray, and the accused person should therefore take the
so that the court may understand the dilemma the defense is in, read the charge sheet so that the court, we can all hear.
Your Honor, just so that I may not appear to be disrespectful, I thought a rejoinder is only restricted to the legal questions.
Yeah,
if my senior colleague was interested in reading the particulars, she ought to have read them at the time was raising the objection, not at the time of the rejoinder.
I don't think so, Your Honor, because if he says that the charge sheet proves the particulars, I would just want us to go home with the ring of these particulars. That he is charged with offensive conduct contrary to section 94(1) of the Penal Code. The particulars: on the 29th day of September 2024, at around 16 hours in Kiambu County, within the Republic of Kenya, in a public place, namely Ruiru Stadium, used abusive words to wit, I said, even if we were cheated, I swear to God again, I swear to God, truly speaking, truly to God, dogs are many than we think. We worked and worked and worked for someone. I swear to God, hustlers were cheated, Mama Mboga was cheated, were cheated, Boda Boda were cheated, clergy, bishops, pastors were all cheated, all teachers were cheated. Our only person who was remaining in the government, talking bravely without folding the tail, Gachagua. I swear to God, if they will take him home, ha ha ha. I swear to God that that person to burn in the stomach while dosing. Ha ha ha. Dogs are many. This is one. I swear to God, how comes we worked for him and does not appreciate us? It's the truth, but we said one thing: if they will debate that motion in Parliament, if they will take him home, the other side of Gachagua, the following morning, led by Kalonzo's team, they will debate the motion to take Ruto home. Are we together? There will be no time. Gachagua will go home alone. They were elected on one ticket, and they will go home together. If Gachagua goes home, Ruto will also go home. Together, we should maintain the chorus. All MPs on the side of sending Gachagua home early in the morning will also take them home. All of them will go home. The other day, they voted yes to raise high cost of living with the intent to provoke a breach. Oh, that's the end of the quote, and then now that it is added, with the intent to provoke a breach of peace. To what set of those particulars are we here for? I just want that the court's mind be applied to this, to see it discloses no cause of, reasonable course of action. It's a lamentation on various issues around the country. This does not satisfy section 94, subsection 1 of the Penal Code. Let those words jumbled up, mixed up together, go in our minds. Is this an offense to which one can plead? Are they multiple offenses? Or is it just a lamentation that the court is being asked to take plea on? A lamentation is the opinion of the person lamenting. So we leave it to the court, and like in the earlier matter, Honorable Waititu is a notable person in this society, being a governor, being a member of parliament, being even a councillor in this city. And he's been a deputy minister, a deputy mayor. We urge for freedom, so that as the court considers, because it may take the court several readings of this to try and make what is being said. I would urge that he gets free bond, he will return to court, and then the court can give us its ruling on this. I urge you also to, let me leave it there. My colleague
to deliver the ruling on preferred. But Yona, look at the offense alleged and the particulars. The offense is that of offensive conduct contrary to section 94, subsection 1. But at the end of the particulars, they say, with intent to provoke a breach of peace. You know, those are two diverse, distinct provisions of the law jabbled up in one piece.
No.
Your Honor, just in brief, on the point that my colleague raised that we had not touched on, we refer court to the earlier case that I had mentioned of Waitiu. on the issue of the breach of peace, because my senior colleague has taken court through the entire particulars. I would refer court to that particular paragraph, and I believe this court will be able to look at that decision. In relation to the question of bail, we have not received indication whether the ruling is immediate or not before we can give our views on the same. We'd like to get directions from court so that we can respond on that question of bail. While we are not directly objecting to bail, we admit that Honorable Waititu has all those positions that my senior colleague has mentioned. However, I wish to bring to court, unlike the previous case that this court has dealt with, Honorable Waititu has an ongoing case before the Anti-Corruption Court, and is currently out on bail in that particular matter. Therefore, his terms must be stringent to reflect that he has an ongoing matter.
Whose fine is 5,000 shillings. So when setting bail, that's how stringent. I just wish to draw the attention of the court to that. And even though he's on other cases, he has not failed to turn up in court. He dutifully attends all these cases.
That's to provide copies of the authorities you are relying on. So
Yes, I can provide.
even to your colleagues.
Yes.
And without reading them, I cannot give you a ruling, otherwise it will not be a considered one.
I undertake to provide them immediately.
Yes. You want to come physically or virtually? Let's make it virtual because of the numbers.
We would appreciate that. Yeah.
Then depending on the outcome.
Maybe whichever way that it goes, we should do it physical for purposes in case, just in case court rules in our favor, so that this person can take it. In case in the event it doesn't, it will still no. Yeah.
May I wonder whether a plea cannot be taken virtually? Really? As long as you can clearly see it is there.
It will depend on what happens thereafter. After the plea.
If they are admitted to bail now,
Yes.
it means that they're still bound by the court. A mentioned date can be set.
Okay.
If the plea must be physical, a mentioned date for the plea can be set during the virtual ruling.
You generally also give directions on the phone because the phone is just confiscated.
He undertook. Then Mr. Oldimu undertook.
But in terms of those particular phones and wherever that was seized by the police,
Oh,
yes,
Waititu.
I'll cross-check with the investigating officer to see whether they have any evidential material before. I undertake to ensure that my colleagues are informed before the end of business today.
You are done? Okay. So ruling on the application relating to the charge sheet on 4th of October this year at 2 p.m. physically. With regard to the question of bail, the alleged offense falls within the category of those covered by Article 49, Sub-Article 2 of the Constitution, in respect of which an accused person should not be remanded in custody. There is no indication that the accused person has failed to turn up for trial in any other case, and the presumption of innocence under Article 50, Sub-Article 2A of the Constitution applies in all cases. Article 49, Sub-Article 1H of the Constitution provides for release on bail or bond on reasonable conditions, and therefore there is no provision, even under Section 123 of the Criminal Procedure Code, for stringent conditions sought by the prosecution. I am convinced that the nature of the charge is not one that can motivate the accused person to fail to turn up for plea taking. The accused person is therefore granted personal bond without surety of Kenya shillings 50,000 to appear before court on 4th of October this year at 2 p.m. Mr. Mboya, we have to break for lunch before coming for your matter. So we come back at...
Are you happy to be free?
You okay?
Are you